Hello, everybody. Hello, Facebook. Hello, YouTube. This is day 14 of the free real estate school for high school students. Yesterday, day 13, it didn't end up working out. We ended up having some tech issues. So today, we are trying something different entirely. We're going to, anyway, it's all different sorts of, we're trying something different. So day 14, chapter 49, the right of survivorship. Chapter 50, the list pendants. Chapter 51, preliminary title reports. Chapter 52, title insurance. Chapter 53, automatic and declared homesteads. Chapter 54, conventional financing. And then, so that's 323 to 365. So we've got 42 pages to read today, which seems pretty reasonable. So let's go ahead and let's jump right into the instructions. Oh, you know what? My volume actually wasn't working until just now. Were you guys able to hear me this whole time? Huh.
Yeah, we can hear you totally.
Okay.
Yeah, you're fine.
All right. Well, if you're just, I'm just gonna act like I'm probably gonna cutting out those first couple of minutes of the video and just jump into. Hey, this is chapter 49. We're jumping into right of survivorship among co-owners, and we're reading through page 365. The right of survivorship amongst co-owners. What is vesting? Vesting is a method of holding title to real estate. Differences in the type of title vesting present different consequences for persons who have interest in property. Title to real estate in California is held in 1 to 4 basic settings. Joint tenancy. Hey guys, I'm teaching. Keep it down a little bit, please. Ownership of fractional interest in real estate by 2 or more individuals, each holding an equal ownership with the right of survivorship. When a joint tenant dies, their interest is eliminated and the surviving joint tenants share the remaining ownership equally. Joint tenants take title together on the same deed. At the same time, hold equal shares in the ownership of the property, and each has the right to possess the entire property, known as the 4 entities. Okay. Tenancy in common. Tenants in common may have varying percentages of ownership in property and may take title at different times and have centralized right of possession. If a joint tenant conveys their interest in the property to another person, that person takes title in the tenant in common. The tenant in common may will their interest in the property to others on their death, since a tenancy in common interest carries no right of survivorship with it. 3. Community property. All property acquired by a married couple in California during a marriage is presumed to be community property, unless acquired as the separate property of either spouse. Under the community property vesting, the ownership interests are equal. Community property with right survivorship. Identical to the community property vesting, but with the inclusion of the words creating the right of survivorship, on the death of a spouse, the surviving spouse automatically becomes the sole owner of the property. Continue below for illustrations of the different types of vesting in speculation. Vesting reflects estate planning. Consider a married couple who, with the assistance of their agent, locate real estate they intend to purchase. They will use monies accumulated during their marriage and their new purchase assist mortgage to pay the purchase price. The agent, as part of their due diligence on any property acquisition, asks the couple how they want to take title on close of escrow. The couple wants the property to be vested in both of their names as a married couple with the right of survivorship. This is actually this is something that escrow this is escrow paperwork. This is something that they fill out with escrow. It's not something that we end up advising people on. On the death of a spouse, the couple wants the surviving spouse to automatically become the sole owner of the property, avoiding probate procedures. Recognizing the community property aspect of their funds accumulated during their marriage, the agent advises the couple they need to take title as a married couple as community property with the right of survivorship, or a married couple as joint tenants. The agent explains the two vestings are identical for future conveying, since both vestings may be severed before death by either spouse to provide an alternative distribution for each spouse ownership interest to others by will, a trust agreement, or other vesting of their interest, and and on death is cleared of the deceased spouse's interest by the surviving spouse, recorded in an affidavit declaring the death of the deceased spouse and attaching the certificate of death. However mindful of the tax consequences of the surviving spouse, the agent recommends the couple vest title to the property as community property with right of survivorship. Like the tax consequences of a joint tenancy vesting by spouses, the surviving spouse is assured a fully stepped up cost basis for the community property. In this example, the agent's advice to vest property as community property with the right of survivorship satisfies the couple's estate planning needs for a holding title to the property. Likewise, since the property was acquired during the marriage, it is considered community property even if the couple vested the property in their names as joint tenants. Additionally, the couple intends to avoid probate procedures on the death of a spouse. Both right of survivorship and vesting avoids enforcement of any contrary provisions in the will of the deceased, since no interest remains under vesting to be transferred by will or otherwise after death. Thank you, Trevor. Community property with the right of survivorship. For the surviving spouse, a community property vesting with the right of survivorship is superior to a simple community property vesting. This is the case even though a simple community property vesting without the right of survivorship also transfers the property of the surviving spouse if the deceased dies in estate with no will or testate with a will, stating that the surviving spouse takes the property. On a simple community property vesting, if no one can test the surviving spouse's right to become the sole owner of the deceased spouse's interest in the property, the surviving spouse needs to wait 40 days following the death before the property can be sold, leased, or encumbered. After 40 days, an affidavit by the surviving spouse is recorded to clear title by declaring the death and attaching a death certificate. A joint tenancy recommendation by the agent produces the same transferability and tax results as does the community property vesting with right of survivorship. They function identically before and after death. However, joint tenancy provides spouses with more flexibility by allowing investing. Although most joint tenancies are created between married couples, a joint tenancy can exist between non-married couples. Conversely, community property vestings are only available to married couples or registered domestic partners. I'll tell you what, it's a lot more fun being able to scroll these than having to just go through one page at a time. Married couple wording in the grant deed. Joint tenancy. John Doe and Jane Doe, married couples, joint tenants. Community property. John Doe and Jane Doe, married couple as community property with right of survivorship. Community property. John Doe and Jane Doe, married couple as community property. Tenants in common. John Doe as married man, as to an undivided one-half interest, and Jane Doe, a married woman, as to an undivided one-half interest as tenants in common. Separate property of one spouse. John Doe, a married man, on his separate property. You never are gonna have to freaking deal with any of this stuff. There's so many people, your escrow company, people are gonna know this stuff, and you're not gonna be put in a situation to where you probably will not be put in a situation. Excuse me, we'll clarify that. where this ends up being something that Europe put under the microscope for. But seeing how the book is requiring that we teach it, let's teach it. Additionally, the number of joint tenants is not limited to 2 as a married couple's ownership of community property interest. Using one deed, any number of co-owners can take title to real estate as joint tenants. The only ownership condition is that the joint tenants take equal ownership interest in the property. Traditionally, the creation of joint tenancy requires the conveyance of 4 unities. Unity of title, meaning the joint tenants take title to the real estate through the same instruments, such as a single grant deed or court order. Unity of time, meaning the joint tenants receive their interest and title at the same time. Unity of interest, meaning the joint tenants own equal shares in the ownership of the property. And unity of possession, meaning each joint tenant has the right to possess the entire property. Today, a joint tenancy vesting is loosely based on these 4 unities. For example, a joint tenancy is currently defined as ownership by 2 or more persons in equal shares. Thus, the joint tenancy co-ownership incorporates the unity of interest into its statutory definition. Similarly, a joint tenancy needs to be created by a single transfer to all of the co-owners who are to become joint tenants. Thus, the historic unity of the title, same deed, and the unity of time, simultaneous transfers, required under common law have been retained in one event. Typically, this is accomplished by recording of a conveyance transferring title to all joint tenants, creating a joint tenancy. A joint tenancy ownership, darn it, this got small on me. A joint tenancy ownership in real estate may be created by any of the following transfers if the conveyance states that the co-owners take title as joint tenants. A transfer by grant deed, quitclaim deed, or assignment from an owner or fee leasehold of a life estate to themselves and others. A transfer from co-owners vested as tenants in common to themselves, or a transfer from married couples holding title as community property, tenants in common or separately to themselves. For the small percentage of joint tenants who are not a married couple, typically family members or lifelong friends, a valid joint tenancy is created when all co-owners make title under the same deed as joint tenants, without stating their fractional ownership interest in the property. Their actual fraction of ownership, if severed or transferred to others, is a function of the number of individuals who took title as joint tenants. For example, 5 co-owners as joint tenants each holds a 1/5 or 20th fractional ownership interest. A joint tenant's right of survivorship. A joint tenancy vesting adds nothing to the legal aspects of the ownership interest held in real estate by each co-owner. Whether the interests held by the co-owners are separate property or community property, a joint tenancy vesting neither enlarges nor reduces the nature of the ownership interest. However, the necessary incident of joint tenancy vesting is the right of survivorship, legally referred to as jus accedency. The right of survivorship in the case of a law doctrine, which is triggered by the death of a joint tenant. Thus, the joint tenant vesting by the incident of the right of survivorship becomes operative only on the death of a joint tenant, at which point the right of survivorship extinguishes the deceased interest and leaves the remaining joint tenants with the entire ownership interest they held as joint tenants. The right of survivorship is a mere expectancy held by each co-owner and not a property right. Ultimately, on the death of all other joint tenants, the last survivor becomes the sole owner of the interest in the property originally owned by all joint tenants. Vesting alone. On dissolution of vesting alone does not transmute community property. On a dissolution of a marriage, all property acquired jointly by a married couple during the marriage, no matter how vested, is presumed to be community property for purposes of division. Further, the community property presumption for married couples does not only come into play when a couple divorces. All property acquired by a couple or by either spouse during marriage is considered community property, unless the couple clearly states their contrary intention to own the individual interest in the real estate as separate property. Conveying community property. As community real estate, both spouses need to consent to the sale or lease for more than 1 year encumbrances regardless of how it is vested. If one spouse, without the consent of the other, sells or leases for more than 1 year or encumbers community real estate, the non-consenting spouse may either ratify the transaction or have it set aside. The non-consenting spouse has 1 year from the recording of the non-consented to the transaction to file an action to set aside the transaction. Encumbering and leasing joint tenancy properties. When real estate and joint tenancy vesting is separate property, as when the joint tenants are not a married couple, or when the married couples in writing agree that their interest is separate property, each joint tenant can sell or encumber their interest in the real estate without the consent of the other joint tenants. Additionally, when the joint tenancy in real estate represents separate property, a joint tenant may lease out the entire property, since a lease is a transfer of possession, and each joint tenant has the right to possession of the entire property. However, consider a married couple who owns community property real estate as joint tenants. One spouse enters into an agreement to lease the property to a term over 1 year, with which the other spouse does not sign. Under joint tenancy rule, either joint tenant alone may lease the property. However, under the community property rule, which applies to the property acquired during marriage, both spouses need to execute a long-term lease agreement with a term greater than 1 year. Severing the right of survivorship vestings. Every co-owner vested as a joint tenant as a community property with the right of survivorship has the right to unilaterally sever the right of survivorship. The severance of a co-owner terminates the right of survivorship in a co-owner's interest. The separate or community property nature of the co-owner's interest in the property remains the same after severing the right of survivorship from the co-owner's interest. A co-owner unilaterally severing the right of survivorship is not required to first give notice or seek consent from other co-owners. To sever the vesting, the co-owner prepares and signs a deed from themselves as a joint tenant or as a community property with right of survivorship back to themselves on recording the deed. On recording the deed, the right of survivorship is severed as having merely revested the co-owner's interest. The deed revesting title is to include a statement noting the transfer is intended to sever the prior vesting. Recording requirement for severance. Recording is necessary to terminate another joint tenant's right of survivorship. The unilateral severance of a joint tenant's interest needs to be either recorded in the county where the property is located before the death of the severing joint tenant, or recorded within 7 days after the joint tenant's death if executed and notarized within 3 days before the joint tenant's death. Additionally, the joint tenancy may be severed by an agreement of the joint tenants. If a written agreement to sever the joint tenancy is signed by all joint tenants, recording or notarization is not required. All the preceding rules for recording a severance apply fully to the severance deed of a spouse seeking to terminate the right of survivorship held under the community property vesting. The unilateral severance of a joint tenancy terminates the right of survivorship. Without the existence of the right of survivorship, each co-owner disposes of their interest in the property of death as they wish, such as by will or inter vivos trust, or by the severance itself. Although the sale of a joint tenant's separate property invested in real estate severs the joint tenancy, a lease or encumbrance of the property by a joint tenant does not. All the procedures for severing a joint tenant are fully available for a married couple to sever the community property vesting, which includes the right of survivorship. Clear title on death by affidavit. However, the deceased joint of interest in the property needs to be cleared from the title by the surviving joint tenant or tenants and will be able to sell, lease, or encumber the property as the sole owner. The new ownership interest of the surviving joint tenant is documented by simply recording an affidavit, signed by anyone declaring the death of a joint tenant who was co-owned by the described real estate. I really like it when the page was a little bit bigger, but you know what? I can't get it to work on my phone, which means I can't scroll through it. So it's just a little bit more boring now, I feel like. All right. The interest in the property held by the deceased spouse as community property with the right of survivorship is extinguished by the same affidavit procedure used to eliminate the interest of a joint tenant, except the surviving spouse or their representative is the only one authorized to make the declaration. Once the affidavit is notarized, recorded, and indexed, anyone conducting a title search on the property will have notice of the joint tenant's death, since the deceased joint tenant is indexed as the grantor. Thus, the surviving joint tenant becomes the sole owner of the property due to the right of survivorship, controlling the vesting of one half. A spouse can unilaterally sever the joint tenancy in community property with the right of survivorship vestings by executing and delivering a deed that conveys legal title to a third party, executing a deed to themselves, executing a written severance of a joint tenancy, or executing a written instrument that evidence is an intent to sever. Additionally, the community property interest of a spouse who executes a deed to themselves to sever the title and eliminate the right of survivorship remains community property. Community property cannot be transmuted to a separate property without the consent of both spouses and a court order. A severance deed to oneself, terminating the right of survivorship, is not sufficient by itself to avoid passing the property to the surviving spouse on death for community property vested as either community property with the right of survivorship or in joint tenancy. A will needs to also be prepared or a living trust established naming the person intended to receive the spouse's community property interest on death. Otherwise, since it's community property, the property will pass by interstate succession to the surviving spouse as though the severance of the vesting had never occurred. Joint tenancy. Tax aspects. Okay. Tax-wise, the main question raised for a married couple when the surviving spouse becomes the sole owner of what was community property is what the surviving spouse's cost basis in the property as the sole owner after the death of the other spouse. The surviving spouse, who has become the sole owner of the community real estate, receives a fully stepped-up cost basis to the property's fair market value on the date of the death which terminated the community property vesting. Thus, the surviving spouse is entitled to a fully stepped-up cost basis in the real estate previously owned by the community without concern for whether the property was vested as community property with or without the right of survivorship, as joint tenants, or in a revocable interior living trust. State law controls how marital property is characterized for federal tax purposes. Federal law is unconcerned with the form in which title is taken to community property. Thus, the real estate owned by a married couple, unless vested as tenants in common, is considered community property for federal income tax purposes. Accordingly, a surviving spouse entitled to the property receives a fully stepped-up cost basis to the property's F&V on the date of the other spouse's death. Holy smokes. Anyone else feel like they need a nap? All right, chapter 50. Oh, page 333. 10 pages in. Really quick, I'm going to show you something here. This is for you, James. Ready for this? Let me check this out. Because I doubt anybody on YouTube is even still watching. Look at that. The wall's done. See that?
I saw that on Facebook, yeah.
That's pretty rad, huh?
Looks good.
And this is just because I need to wake up a little bit. Look at that. Bam. Isn't that cool? I think that's pretty
How much
good.
did the custom light cost?
What was that?
How much did the custom light cost?
How much did it cost to make the wall?
The sign.
The sign? Young man, you're not supposed to ask this sort of questions. That's rude. I'm just playing. I got the sign from Light Bright. You know the toy that you played with as a kid, and it was like $750.
Looks cool though.
Yeah, it does look cool. Thank you. I appreciate that. All right. Anybody who's actually still watching on YouTube is going to be like, what was that all about? That was weird. All right. Here we go, my friend. We're going to keep going. You ready? Chapter 50. The lispendens. Clouding the title with a notice. Lis pendens is Latin for pending litigation. More commonly, a lis pendens is called a notice of pending action. In practice, a recorded lis pendens puts all persons on constructive notice that the title or right to the possession of real estate is in litigation. The purpose of recording a lis pendens is to preserve a person's rights to real estate under the dispute for which the owner is resolved. Thus, the buyer who acquires an ownership interest in the property after lis pendens describing the property has been recorded takes their interest to the property subject to someone else's, the claimant's right. Without a recorded lis pendens or physical possession of the real estate, the person who claims an interest in title or the right to possession runs the risk the owner will encumber or convey the property to another buyer, lender, or tenant who is unaware someone else already holds an interest in the property, title, or possession to real estate. A lawsuit needs to affect title or the right to possession of real estate to support the recording of a lis pendens. Lawsuits affecting the title or possession of real estate include a specific performance of an unclosed transaction or rescission of a closed transaction, judicial foreclosure of a trust deed lien by a lender, foreclosure by a mechanic's lien by a construction contractor, cancellation of a grant deed or other conveyance by a prior owner, fraudulent conveyance to be set aside as voidable by creditors, evictions and suits concerning unexpired leaseholds brought by tenants or leasehold lenders, termination or establishment of an easement between neighboring property owners, government declaration that a building is uninhabitable, ejectment of an unlawful occupant other than the tenant from real estate by an owner, partition or sale of the real estate by a co-owner, quiet title, eminent domain actions, and divorce proceedings involving real estate. Real estate lawsuits. A lis pendens is also permitted in the following lawsuits over real estate: action by adverse possessors to determine claims to title, actions to establish lost land records, actions to determine adverse interest in any liens, clouds, or real estate arising out of public improvement easements, actions by purchasers or the state to quiet title to tax deeded property, actions by innocent improvers of real estate against owners or lenders of record, actions of an improvement bond, and actions terminating or establishing an easement, except for a public utility easement. The lis pendens process. To record a lis pendens, the lis pendens is required to identify the parties to the lawsuit and give an adequate description of the real estate. While the object of the lawsuit and the effect on title or possession of lawsuit does not need to be stated in the lis pendens, the property of the lawsuit to be stated in the lis pendens for it to be considered an absolutely privileged publication. Editor's note: an absolute privilege covers any publication during a judicial proceeding which is authorized by law, including a lis pendens. A publication made under absolute privilege bars a slander of title action against the person wrongfully claiming an interest in the property. A lis pendens a lis pendens is properly of record. They must have said that wrong. And when a lis pendens is properly recorded when it is filed and indexed in the county recorder's office of the county where the property is located. Recording and indexing a lis pendens constitutes constructive notice to all persons about the existence of a dispute over title or possession of a property. Any buyer, lender, or tenant who is later conveyed an interest in the property is bound by the final resolution of the dispute. Title insurers and specific performance actions. Title companies usually refuse to insure title when a lis pendens is recorded, which involves a specific performance action. Without title insurance, buyers will not buy, lenders will not lend, and tenants will not occupy the property. However, a lis pendens is buyer's specific performance action does not interfere with the title company, ensuring a lender's trust deed, which secures a debt in an amount less than the price the buyer will be paying for the property. As a result, property subject to specific performance actions by a buyer is often rendered unmarketable while the lis pendens remains in effect. This has got to be the single most boring day we've had yet. Am I right?
Yeah, well, maybe the third day, but this is pretty boring.
The third day was kind of rough. Like, yeah, this is the I'm like, this is the absolute.
Reading these books almost wanted me to get out of real estate or just stop, until I found you and like my dad was into it. But like reading these books by itself was just draining.
Yeah.
Because it's not what real estate's about.
Correct. And the thing is that there's some good stuff that we've been able to find, of course, right? And we've talked about the good stuff when it comes up. But some of this stuff is just like so exhausting. So anyway, I'm trying today, but today it is not easy. Today I'm wanting to fall asleep. This is rough. All right. Did we read Expungement of a lis pendens? I feel like we did. Let's say we did.
Yeah.
We definitely did, without a doubt in my mind. Chapter 51, Preliminary Title Reports. So, did you watch on Facebook today with Anthony Andre? The title guy came into the office. They for commission boot camp today. I just didn't know if you'd watch. I know that you were at school during the day, but title reps, they can't do any sort of like co-marketing. Like they can't even buy you dinner. If your title rep takes you out to coffee, they can't pick up the tab. So there's all sorts of like legal rules based on what they can and cannot do. But what they can do is they can provide you with information, and so that's what information is the most valuable thing anyway, right? It's the reason why Facebook is a multi-billion-dollar company. It's because of information. And so like So anyway, so like your title guy can set you up with an account, and if you want to get a hold of when you and your dad get started. If you want to reach out to Anthony Andre over there at Ticor Title, him and his team, Hector, they could set you up with an app. And there's all sorts of really great tools. And, they can pull data based on, who is likely to sell, based on like their equity. And, anyway, it's a really solid company. All right, we're going to move forward into this stuff. Here we go. Preliminary title reports. An offer to issue title insurance. A preliminary title report is intended to disclose the current vesting and encumbrances of which may be reflected on public record affecting a property's title. Encumbrances reflected on the preliminary title report include general and special taxes, assessments and bonds, covenants, conditions and restrictions, easements, rights of way, liens, and interest of others. A preliminary title report, also known as a prelim, is not a representation of the condition of the title or policy of title insurance. Unlike an abstract title, a prelim cannot be relied on by anyone and imposes no liability on the title company. Very easy to pull a prelim. Very easy to get this information. A lot of it's public. No duty to accurately report. A title insurer has no duty to accurately report title defects and encumbrances on the prelim, shown as exceptions in the proposed policy. A prelim is no more than an offer to issue a title insurance policy based on the contents of the prelim. Further, the offer may be modified by the title company at any time before the policy is issued. The closing of purchase escrows is contingent on the buyer's approval of items in the prelim to set the conditions on title consistent with the expectations of the buyers on entering into the purchase agreement. The buyer, their agent, and escrow review the report for defects and encumbrances on title inconsistent with the terms for the seller's delivery of title set on the purchase agreement and escrow instructions. They also look for title conditions which might interfere with the intended use or change in the use of the property contemplated by the buyer. Remember before when we were talking about buying things that were R5 or RR, or making sure that the property is, actually going to be able to have be used for what you're buying it for? That's basically what they're saying here. Title is, they're going to check to actually make sure that you're able to build as many, structures as you want to be able to build. If you're looking for agricultural, if you're looking for commercial, they're going to make sure that it is going to be used for that intended use. I should stop trying to act like I'm not drinking a Frappuccino. All right. The closing and purchase escrow is contingent on the buyer's approval of items in the prelim to set the conditions of title consistent with the expectations of the buyer on entering into a purchase agreement. The buyer, their agent, and their escrow review the report for defects and encumbrances on title inconsistent with the terms on the seller's delivery of the title set in the purchase agreement and escrow instructions. They also look for the title conditions which might interfere with any intended use or change in the use of property contemplated by the buyer. Escrow reliance. Escrow relies in part on the items approved and disapproved in the prelim to carry out in its instructions to record grant deeds, trust deeds, leaseholds, or options which are to be insured. Typically, the escrow instructions call for the closing when the deed can be recorded and insured, subject only to taxes, CC&Rs, and other encumbrances agreed and approved in the instructions. Ultimately, it is the escrow officer who, on the review of the prelim, advises the seller of any need to eliminate defects or encumbrances on title which interfere with closing as instructed. The prelim and any last-minute data down research of title conditions are used by escrow and the title insurer to review any of the title problems to be eliminated before closing, and instructed obtain title insurance for the documents when recorded. The title insurer's date down of the prelim prior to the closing may turn up to title defects or encumbrances not included in the prelim. These occur by error on the part of the insurer or by the recording after the preparation of the prelim. In any case, the title company may withdraw its offer under the prelim. The title company then issues a new prelim offering to issue a policy on different terms. Basically, a title company, a title rep, is like a punter or like a field goal kicker. The only time that you really recognize them is when they mess up. Like if they drop the ball in the fourth quarter or something like that. And so, like I said, I've been using the same title guy for 7 or 8 years now, and it's because he hasn't dropped the ball in the fourth quarter. That's really what it is. So in order to have a good escrow person, they're like very central to your transaction. They're like right up there with the quarterback. But having a good title rep, it's like having a consistent field goal kicker. You don't realize how important it is until you have David Akers and you're the San Francisco 49ers trying to go on a Super Bowl run, and he's kicking everything wide right and wide left. Okay, and that's the truth. That's what it is. Escrow reliance. Checking in with you, Fred. That's what we're talking about. We're talking about field goal kicking. And I'm trying not to fall asleep while reading.
I was worried about you. said David Akers. He's our cousin.
David Akers, the field goal kicker?
I'm just kidding. I just wanted to see what you'd say.
I'm autistic. I would just tell you the truth, right? If you're a woman and you want to ask, you want to find out if you look good, if something looks nice on you, you ask an autistic person. So for me, David Akers
is the worst.
The worst. Back when I still cared about football very deeply. I got very emotional when we lost this NFC championship to the Seattle Seahawks. Anyway, another day. I'm trying to do everything but talk about this damn title stuff. This is awful. This is awful. Fred, I'll tell you, what do you teach?
Business, all kinds. I teach a bunch of things.
So there's got to be days when you just are like, this is the worst.
You have no idea. It's, especially online right now, it's terrible. But
Today's one of those days. I'm like, I feel bad for James.
Yeah.
All right. Well, I'm going to keep going because
it's important stuff still.
It is still important stuff. 20 more minutes. Here we go. Escrow reliance. Escrow relies in part on the items approved and disapproved in the prelim to carry out its instructions to record grant deeds, trust deeds, leaseholds, or options which are to be insured. Typically, escrow instructions call for closing when the deed can be recorded and insured, subject only to taxes. CC&Rs and other encumbrances as agreed and approved in the instructions. Ultimately, it is the escrow officer who, on review of the prelim, advises the seller of any need to eliminate defects or encumbrances on title which interfere with closings as instructed. The prelim and last-minute date-down search of title conditions are used by escrow and the title insurer to reveal any title problems to be eliminated before closing, and as instructed, obtain title insurance for the documents when recorded. The title insurer's date down of the prelim prior to closing may turn up title defects or encumbrances not included in the prelim. These occur by error of the part of the insurer or by recording after the preparation of the prelim. In any case, the title company may withdraw its offer under the prelim. The title company then issues a new prelim offering to issue a policy on different terms. Prelim versus abstract of title. Prelims were once compared to abstracts of title. An abstract of title is an accurate factual representation of title to the property being acquired, encumbered, or leased. Thus, an abstract of title may be relied on by those who in order as an absolute representation of the conditions of title. An abstract of title is a statement of facts collected from the public records. An abstract is not an insurance policy, which is a dollar limit on the insurer's liability as is set in policy of title insurance. The content of an abstract is intended by the insurance company to be relied upon as fact. Thus, the insurer is liable for all money losses of the policyholder flowing from a failure to accurately state all conditions of title in the abstract they issue. Okay, 14 more pages today. Title insurance, here we go. Identifying an actual loss. A policy of title insurance is the contract under which a title insurance company reimburses or holds harmless a person who acquires an interest in real estate against a monetary loss caused by encumbrances on title that is not listed in the title insurance policy as an exception to coverage, and the insured policyholder was unaware of when the policy was issued. Thus, a policy of title insurance is a form of indemnity insurance. Title insurance policies are issued as one of the several general forms used by the entire title insurance industry in California. The policies are typically issued to buyers of real estate, tenants acquiring long-term leases, and lenders whose mortgages are secured by real estate. As an indemnity agreement, a title insurance policy is a contract. The terms of coverage in the policy set forth in the extent of the title insurance company's obligation, if any, to indemnify the policyholder for money losses caused by an encumbrance on title. Encumbrances unknown, undisclosed. Almost all losses due to the reduction in the value of real estate below the policy limits arise out of the encumbrance. An encumbrance is any condition which affects the ownership interest of the insured. The word encumbrance is all-encompassing. Any right or interest in real estate held by someone other than the owner by which diminishes the value of the real estate is considered an encumbrance. Encumbrances on title include covenants, conditions, and restrictions limiting use, reservations of a right-of-way, easements, encroachments, trust deeds or other security devices, penancies of condemnation, and leases. Property improvement and use not covered. Physical conditions on the property itself are not encumbrances affecting title. Accordingly, title insurance policies do not insure against open and notorious physical conditions which exist on the property. A buyer is always presumed to have contracted to acquire property subject to known and physical conditions on the property which impede its use or impair its value. In the case of encumbrances, recorded or not, no such presumption exists. A title insurance. A title insurance policy is not an abstracted title, which warrants or guarantees the non-existence of title encumbrances. Instead of receiving a guarantee of title conditions, the named insured on the policy is indemnified up to the policy dollar limit against the money loss caused by title conditions not listed as an exception or an exclusion in the policy. Under a title insurance policy, the title company only covers the risk of monetary loss caused by an encumbrance which is not listed as an exception or an exclusion to coverage and was unknown to be the named insured at the time of closing. Thus, the title company has no obligation under a policy to clear the title of the unlisted encumbrance. The title insurance company issuing a policy of title insurance has two underwriting options when its title search reveals its encumbrance affecting the title. List the encumbrance in the preliminary title report, prelim, requiring the parties to either eliminate it or accept it as an exception to the coverage in the policy of title insurance to be issued, or insure against the encumbrance by writing over the encumbrance, i.e. not listing it as an exception and assuming any risk of the loss connected with it. When title companies write over a known encumbrance, they usually demand an indemnity agreement from the person responsible for eliminating the encumbrance. This encumbrance typically takes the form of a money lien, such as a mechanic's lien, money judgment, or blanket encumbrance. Thus, the title company can recover for a third-party guarantor if a claim by the insured is later paid due to the encumbrance. Additionally, a title policy is not a representation guarantee of the non-existence of encumbrances that are not listed in the policy if an encumbrance is not known to the named insured, such as the buyer or lender, and it is not listed as an exception to the policy. An insured's claims against the insurers for money in excess of the policy limits cannot be based on the insurer's negligent preparation of the encumbrances excluded from the coverage. Similarly, a claim on an erroneous prelim cannot be based on negligent preparation. However, a title insurer might intentionally write over encumbrances at the request of the seller. If the buyer is not notified the encumbrance exists, the insurer is liable for actual losses in the excess of the policy coverage. In this instance, the insurer breached the implied covenant of good faith and fair dealing imposed on title companies as duty owed to the insured. Introduction to title policy forms. Title insurance is purchased to assure real estate buyers, tenants, and lenders the interest in title they acquire is what they bargained for. A policy of title insurance is broken down into 6 operative sections, including the risk of loss covered, called insuring clauses, which are based on completely unencumbered title at the time of transfer. The risk of loss not covered, comprised of encumbrances arising after the transfer of known or brought about by the insured, called exclusions, which are boilerplate set of title conditions. Identification of the insured, the property of the vesting, the dollar amount of the coverage, the premium paid, and the recording, called Schedule A. The recorded interest, i.e. any encumbrances affecting title, and any observable on-site activities which are listed as risks agreed and assumed by insured and not covered by the policy, called exceptions, which are itemized for all types of coverage in Schedule B. The procedures called conditions for claims made by the named insured and for settlement by the insurance company on the occurrence of loss due to any encumbrance of title, which is not an exclusion or exemption to the coverage granted by the insuring clauses, of course, and any endorsements for additional coverage or removal exclusions or pre-printed exceptions from the policy. Insuring clauses. Coverage under the broadly worked insuring clauses of a policy title insurance indemnifies the named insured for risks of loss related to the title due date to anyone making a claim against title to the real estate interest, the title being unmarketable for sale or as security for financing, any encumbrances on the title, and lack of recorded access to from the described property. Exclusions from coverage. All title insurance policies contain exclusion section. The exclusion section eliminates from coverage those losses incurred by the insured buyer, tenant, or lender due to use ordinance or zoning laws, unrecorded claims known to be insured but not to the title company, encumbrances or adverse claims created after the date of the policy, claims arising out of the bankruptcy or due to fraudulent conveyances to the insured, police power in eminent domains, and post-closing events caused by the insured. All policies of title insurance on Schedule A set forth the property interest the insured acquired, the legal description of the insured property, the date and time coverage began, the premium paid for the policy, and the maximum total dollar amount to be paid for all claims settled. Exceptions to coverage. In addition to the policy exclusions, a policy coverage under its no encumbrances insuring clause is further limited by scheduling exceptions in the policy. The exception section contains an itemized list of recorded and unrecorded encumbrances which are known to the title company and affect the insured title. While the existence of these known encumbrances is insured against the insuring clauses, they are removed by Schedule B as a basis for recovery under the policy. An ALTA policy includes a set of pre-printed exceptions setting forth risks assumed by the insured buyer, tenant, or lender. Claims and settlements. Lastly, a policy of title insurance includes a conditions section. The conditions section outlines and procedures the insured policyholder needs to follow when making a claim for recovery under the policy. Also set forth are the settlement negotiations or legal actions available to the title company before paying a claim. Owner policies for buyers. Several types of title coverage are available, including a California Land Title Association standard policy, an American Land Title Association owner's extended coverage policy, an ALTA residential policy, and an ALTA homeowners policy. The CLTA standard policy. The CLTA standard policy is purchased solely by buyers, carryback sellers, and private lenders. The CLTA standard policy insures against all encumbrances affecting the title, which can be insured by a search of public records prior to the issuance of the policy. Any encumbrances not recorded, whether or not observable by an inspection or survey, is not covered due to the CTLA policy exclusions and standard exceptions. Additionally, the CTLA standard policy, as well as the ALTA policy, protects the insured against, holy smokes, that's our 5-minute warning for class. I'm quite all right with that. That was a rough one. Thank God we never have to read this again, right? Okay. Okay, chapter 53, 353. So, 12 pages or so of homework or so. I'm sure that everybody's going to, rush off and read that right now. And just go ahead and knock it out so that you don't have it hanging over your head. All right. Any questions in the chat? Let's see. Oh, there are questions in the chat. I need to step away for a second. Someone is coming over to buy something from me. I hope it was bought. Get it sold? Sold. How often do title companies ever need to pay out any money? I have never been a part of a situation where that has happened. So that's why all of that was so awful. But I could certainly find that out for you. I would think it's fairly rare. Yeah, I've never seen it. 400 something transactions. Where's a good place to really get unable understanding of titles and what an agent needs to know about them? Hector and Anthony Andre with Ticor Title, they literally they do a class regularly, and they did one today. And I actually think that the class might even be on the Facebook page. Amy? Is Amy still here? Okay, Amy's not still here. But I'm just about 100% positive it's on the Facebook page. But yeah, Anthony Andre, Ticor Title, Hector over there, he teaches a class, and they'll set you up with the app, and then that way they'll make sure that you are able to, to utilize your farming material. Should James and I reach out to the title person? we'll probably be using from you and or Janice. I don't know who Janice works with. Whatever you guys want to do. At the end of the day, you guys have to find people that you're comfortable working with. You know what I mean? Janice, regardless, is your mentor, right? But that doesn't mean that every single one of her affiliates are going to be affiliates that you are going to have a relationship with. You know what I mean? So, Tessa, Amy,
Yeah.
the Anthony Andre's title class.
Yeah.
Is it on the Facebook page today?
It is.
Okay, cool. And that was Hector?
Yes. Hector
Okay.
Gomez with Tycor title.
Okay, we're
What's up, students?
so this is Fred. Fred's a high school teacher. This is
Hi,
his son
Fred.
James.
Nice to meet you. Hi, James.
So
Yeah, so we did a really good commission boot camp today. There's a great app that you guys can download with Team Tycor title. And if you guys watch that commission boot camp class, he'll actually break down how you can make that app work for you instantaneously. So it really benefits you when you're outdoor knocking and cold calling, because you can pull up specifics like those most likely to sell, so that when you go outdoor knocking, you're not going to spend the whole day, and you might have an hour that you go outdoor knocking and it's very targeted and specific, so that you're more likely to get a solid lead.
cool.
Thank you so much.
You're welcome.
Thanks, Sam. Okay, so there you go. So today was the day. So I've kind of got this thing going on with the real estate school, and then Amy's got this whole other thing going on with commission boot camp, and so a lot of different things happening. So yeah, feel free to just go to that Facebook page. Do you guys both know where to find that? Facebook.com/Educate Empower Explore California. I'll put that in the chat. And it's easy to find by finding me on Facebook, but Facebook.com/Educate Empower Explore. Not .com. That wouldn't make any sense. Old man Serpa. Educate Empower Explore California. So that's our Facebook page right there. And then that way you could go ahead and I try to get everything that goes on our Facebook page loaded onto the YouTube page, but it doesn't always happen. I'm a little bit behind right now. James, you like that video of our community neon sign?
Yeah.
Just got on and talked a little bit of noise today. All right, let's see. Any other questions for me today, my friends?
Nope, got it. That's perfect. Thank you. Oh, I guess we just found out that we will be probably taking our test within a week because they're releasing dates now. We're doing a cram study, and we should be testing within the week.
That's fantastic. Oh yeah, James talked to me about some crash courses. I think Stuart Jacobson has something going on, but I bet you guys are going to be fine. I passed my first time. I see a lot of people saying, "Oh, it took me 5-6 times," but you know what though? Like, not you guys. I think you guys will be just fine. You guys will be all right.
They were good. We got a good cram course. Plus, we went through a good study materials, and with your help and everything else, we've been.
Did you get a date yet?
No, we could have gotten them tomorrow, but we're not ready for tomorrow. We're gonna probably get it next Friday or something.
How fantastic!
Yeah, I think we'll be ready next Friday.
Good, excellent. All right, my friends. We'll be looking forward to getting you guys, licensed and getting you in the office.
Same here. We look forward to it, sir.
We're looking forward to seeing you guys around. You guys have a good rest of your night. I'll see you guys tomorrow.
Quick question: have you
Me
seen
too.
or an adult Oriana Chang? Has she been in there or no?
What was the name?
Oriana.
Oriana. Amy, is Oriana in the adult program?
I haven't seen an Oriana.
Not yet. Don't think so.
All right. I was hoping she'd show up. She was my student that I was trying to recommend, but. All right.
I also know that there are people that are, they're watching on YouTube or whatnot, and they're not necessarily logging in live. And we're also telling people, we're encouraging people to just watch it when they can. And I don't remember ever seeing her logging in live.
If she came in. She's a nice girl. She's one of my students that just graduated and she really wanted to go into real estate, but she was displaced. Her home, her and her mom had to move anyway. So I know she's working in Moreno Valley.
One second, I'm going to kill the recording here, and then let's keep talking.